Welcome to the Open Meeting Law webinar with the Data Practices Office. Thank you for joining us. Data Practices Office is a small office in the Department of Administration, and we're a statewide resource on data practices and the open meeting law. Most of what we do is respond to questions related to those laws from members of the public and government. So if you have a question about these laws, please feel free to reach out to us at any time. We also assist the Commissioner of Administration with issuing advisory opinions and provide legislative assistance and training. This PowerPoint is posted on our website, so if you aren't able to download a copy, the slides are on the page where you registered. We also record our webinars, so if you missed part of today's discussion or want to go back and watch it again or find one of our prior series, they are posted on the Data Practices Office YouTube page. You can find more information at the URL listed on this slide, and we'll have another slide later with more information on accessing those resources after the webinar. Today's webinar is focusing on the open meeting law. We'll start with a refresher about the general requirements of the law, and then we'll highlight questions that we've received in the past several months about the law. Before getting started though, I do want to highlight a few online open meeting law resources that are already available. The Data Practices Office website has several web pages with guidance about the open meeting law's various requirements. These pages include information about how public bodies can close meetings appropriately, how to provide notice for different types of meetings, the requirements that public bodies must meet if they conduct a meeting using interactive technology, as well as a discussion of some of the different myths and misconceptions about the requirements of the open meeting law. Additionally, you can find substantial guidance about the open meeting law in the various Commissioner of Administration advisory opinions, all of which are available on our website. We do have a function for the opinion library that allows you to search by keyword, topic, public body, or opinion number. You can also filter the search results to only display open meeting law opinions. Of course, you can always reach out to our office directly by email or phone if you want to discuss specific questions you have about the open meeting law's requirements. Okay, let's start with a refresher of the open meeting law's requirements before we turn to some of the questions we've recently seen. The open meeting law is contained in Chapter 13D of Minnesota statutes, which states that all meetings of public bodies must be open to the public, with limited exceptions. It's a short law that focuses on technical requirements, and it leaves some room for interpretation. As a result, the Supreme Court has often stepped in to clarify and sometimes complicate the analysis of the law. That said, the Supreme Court has identified three primary policy objectives behind the open meeting law, including prohibiting official public body business from being conducted in secret meetings, to help assure the public is informed about the workings of a public body, and to ensure that members of the public have an opportunity to express their views to the public body. Notably, though, the open meeting law does not require public bodies to provide time during its meetings for public comment. The open meeting law does not define what is considered a meeting that is subject to the requirements of Chapter 13D. However, the Minnesota Supreme Court has stepped in and provided the quorum rule to define when a meeting of a public body is happening. There's two parts to this rule to determine when a meeting is subject to the open meeting law. First, there must be a gathering of a quorum or more of the full public body, or a quorum of the body's committees, subcommittees, etc. And second, the quorum of members discuss, decide, or receive information as a group on issues relating to the body's official business. If both factors are happening, then you have a meeting that's subject to the requirements of the open meeting law. However, there are situations when public body members may be together and the open meeting law does not apply. So, the open meeting law does not apply to gatherings where there are fewer than a quorum of public body members. For example, if two school board members of a 7-member school board are discussing an issue with a constituent, it's not a meeting subject to the law. Next, the Supreme Court has determined that the open meeting law does not apply to chance or social gatherings, such as a holiday party or a retirement party for an outgoing city administrator. However, the members will want to ensure that they are not discussing public business at these events. Lastly, there are both Attorney General and Commissioner of Administration advisory opinions that state the open meeting law does not apply to trainings or team building events, so long as the trainings focus on general issues. These trainings should not include discussions of the body's official business, and these opinions note that if business will be discussed, then the open meeting law will likely apply. That said, public bodies should always be aware of the public's perceptions even when the open meeting law does not apply. Often, the loss of the public's trust or complaints that members are not being transparent because members are getting together outside of a formal meeting can be more difficult to manage than an actual violation of the law. Although there are situations when public body members can gather without the open meeting law applying, members should still be careful that they are not holding serial meetings in violation of the law. Serial meetings are meetings of groups of less than a quorum of public body members, and these meetings are conducted with the intent to avoid a public hearing or to come to agreement on issues outside of public view. However, whether serial meetings have occurred in violation of the open meeting law depends on the specific circumstances of the situation, and it needs to be clear that the serial meetings were designed to avoid conducting business before the public. So, any issues involving serial meetings do need to demonstrate that the public body members had the intent of avoiding open meetings. We've covered what types of gatherings are considered meetings, so let's turn to the different types of meetings that public bodies can hold and the required notices for these meetings. First, there are regularly scheduled meetings. These are your typical biweekly or monthly meetings planned out well in advance. Basically, these are the meetings you set your watch to. Next are special meetings, which are any extra meetings that a public body holds that don't appear on the schedule of regular meetings. Finally, there are emergency meetings. There's not a definition of what should be considered an emergency for the purposes of the open meeting law, which means we use the general understanding of an emergency. For practical purposes, an emergency meeting involves situations or issues that are so pressing that a public body cannot wait 3 days to provide notice for a special meeting. So let's dive into the meeting notice requirements. For regular meetings, a public body needs to keep a list of its regular meetings on file at its primary office location. There are some additional aspects to keep in mind, though. When there's a change in the date, time, or location of a regular meeting, then the public body needs to meet the special meeting notice requirements. And just to clarify, the regular meeting does not become a special meeting. Rather, Section 13D.04, Subdivision 1 simply states public bodies must give the same notice as special meetings, and there's no language in the open meeting law that converts the regular meeting to a special meeting. A rescheduled regular meeting remains a regular meeting. On a different note, local public bodies also do need to notice the locations of members when the members are attending a meeting by interactive technology. More on that in a bit. Beyond the schedule of regular meetings, there's no additional requirements to provide any advanced notice. Of course, this doesn't prohibit public bodies from providing alerts or notices to the public about upcoming regular meetings, which may certainly be useful to the public. It's simply not required by the law. Next, we have special meetings, and as a reminder, these are any meetings that do not appear on the regular meeting schedule. So, for the requirements, at least 3 days in advance of the meeting, you must post a written notice of the special meeting on the principal bulletin board or usual meeting door. Additionally, you must provide notice to individuals who have made written requests to receive special meeting notices or publicize the notice in the official newspaper designated by the public body. The notice itself must include the date, time, and location, as well as the purpose of the meeting. A few notes here. When calculating the 3 days, you do not count the day of the posting, but you can count the day of the meeting. For example, you can post on Friday for a meeting happening on Monday. You don't count Friday, but you do count Saturday, Sunday, and Monday. Additionally, special meetings are limited to addressing issues that are described in the meeting notice. So the notice needs to adequately describe all topics that will be discussed or acted upon. The Commissioner addressed this requirement in Advisory Opinion 22-009, so take a look at that opinion for further guidance. Lastly, emergency meeting notices. As I mentioned earlier, the open meeting law doesn't have a definition of an emergency, so when an emergency has occurred, it's left up to the discretion of the entity. That said, emergency meetings are appropriate only in exceptional circumstances when public safety is jeopardized, such as dealing with natural disasters. When it comes to noticing an emergency meeting, the public body needs to make a good faith effort to notify all media outlets that have requested notice, and the public body needs to include information about the subject of the emergency meeting. However, there's no requirement to post the notice on a bulletin board or a meeting room door. Also, the public body must create minutes that specifically document discussions of any issues not directly related to the emergency. There are a few additional notes for state public bodies when it comes to meeting notices. First, all the notice requirements we discussed apply only when the public body's enabling statute does not describe how the body must provide notice. When it comes to the schedule of regular meetings, a state body can keep the schedule of its regular meetings on file at its primary office, or it can post the schedule on its website. Finally, a public body can meet the special and emergency meeting posting requirements by publishing the notice on its website or in the state register. Let's now talk about the requirements when it comes to closing meetings. There are certainly times when public bodies discuss sensitive information. However, public bodies can close meetings only when specifically required or permitted to do so by law, which we'll cover in a minute. To close a meeting, the public body must provide a statement on the record that provides the legal authority to close the meeting and describe what will be discussed during the closed session. For example, a sufficient statement might be, this meeting will be closed as permitted by Section 13D.05, Subdivision 3A, to evaluate the performance of the city administrator. Additionally, closed sessions must be electronically recorded, and the recording must be retained for at least 3 years unless the law specifies otherwise. Notably, meetings closed for attorney-client privilege purposes do not need to be recorded. One final note before moving on, the open meeting law does not contain a general personnel exception to closed meetings. In other words, the discussion of employees' private personnel data or similar personnel issues cannot be used as the sole justification to close meetings. Let's highlight the situations described in Section 13D.05, Subdivision 2, when a meeting must be closed. These situations include discussions that would identify alleged victims or mandated reporters of criminal sexual conduct, domestic abuse, or maltreatment of minors or vulnerable adults. Discussions involving active criminal investigative data or internal affairs data related to allegations of police officer misconduct. Discussions of private education data. Discussions that involve not public medical data, welfare data, or mental health data. Any discussion involving an individual's health records. Lastly, meetings must be closed for a preliminary consideration of allegations or charges against an individual subject to its authority. However, once a public body decides that discipline of any kind may be warranted, subsequent meetings about the issue must be open to the public. There are other situations when a public body may decide to close a meeting, but it can also choose to keep the meeting open. These situations, which are described in sections 13D.03 and 13D.05, subdivision 3, include discussions about labor negotiation strategies, negotiation developments, or to review labor negotiation proposals. Discussions involving specific types of property transactions, and receiving security briefings or discussing specific types of sensitive security issues that could pose a danger to public safety or compromise security procedures. A public body can also close a meeting when it is evaluating the performance of an individual subject to its authority. However, the body needs to identify the individual prior to closing the meeting, and it must summarize the results of the evaluation at the next open meeting. The meeting must also be open at the request of the individual who is being evaluated. Additionally, meetings may be closed if required to do so by another law or as permitted by the attorney-client privilege. Some added notes on the attorney-client privilege aspect. Closing a meeting for this reason can only be done in narrow circumstances. Public bodies cannot close meetings in order to receive general legal advice or even when there is a mere threat of litigation. Rather, public bodies need to balance considerations of openness and the need for absolute confidentiality before closing a meeting for attorney-client privilege purposes. And the meeting should be closed only when there is a need to protect conversations because litigation appears to be likely or is ongoing. Be sure to note the citations on this slide that provide some excellent analysis if you have questions about when a public body can close a meeting for the purposes of attorney-client privilege. Okay, we're going to transition into the requirements for remote meetings, specifically sections 13D.015, 13D.02, and 13D.021 allow members of public bodies to attend meetings remotely so long as the applicable conditions are met. A few things to keep in mind with these requirements, though. First, the requirements of these sections apply only when one or more members of the public body are attending the meeting remotely. The requirements are not applicable when a public body decides that it will stream a meeting or invite guests to join the meeting remotely. Additionally, there is no requirement for public bodies to broadcast an open meeting to the public, whether it's over the internet or on television. In other words, none of the requirements of these sections will apply when all members of the public body are attending the meeting in person. One other note here, the open meeting law defines interactive technology as a device, software program, or other application that allows individuals in different physical locations to see and hear one another. In short, public body members need to be able to both see and hear each other when attending a meeting via interactive technology. So let's review each of these sections. We'll start with Section 13D.015, which permits state-level entities to hold meetings by interactive technology so long as certain conditions are met. Local public bodies, such as county commissions, city councils, or local school boards, for example, cannot use this section to hold meetings remotely. This section is reserved solely for state entities required to hold open meetings, such as the various state health licensing boards, professional licensing boards, and other public bodies, such as the Public Utilities Commission and Minnesota Racing Commission, among others. The conditions to hold a meeting under Section 13D.015 include all members of the participating entity must be able to hear all discussion and testimony, regardless of their physical locations. All members of the public who are attending the meeting at the regular location must be able to hear all discussion and all votes of the entity's members. Additionally, members of the public must be able to participate in testimony when applicable. At least one member of the entity must be physically present at the regular meeting location. Finally, all votes must be conducted by roll call. Next, 13D.015 subdivision 4 requires that public bodies must, to the extent practical, allow the public to monitor the meeting remotely. This requirement could be met through providing links to watch the remote meeting via a computer or a personal device, or by providing dial-in information for a conference call. Finally, a state public body does need to post a notice on its website that some members may be participating electronically at least 10 days in advance of a regular meeting. If it is a special or an emergency meeting, the public body must provide the electronic participation notice according to the applicable notice requirements under Section 13D.04. Okay, let's turn to Minnesota Statutes Section 13D.02, which permits local public bodies to hold meetings by interactive technology so long as certain conditions are met. These conditions include all members must be able to hear each other, as well as all discussion or testimony. Members of the public who are at the meeting location must be able to hear all discussion and testimony, as well as be able to hear all votes of the body's members. At least one member of the public body must be physically present at the regular meeting location. Votes must be conducted by roll call. Finally, each location where a member of the body is remotely attending the meeting must be open and accessible to the public. However, there are a couple of exceptions to this requirement. First, the location of the member doesn't need to be open to the public if that particular member has not participated remotely in a 13D.02 meeting from an inaccessible place more than 3 times in a calendar year, and the member is serving in the military and happens to be at a required drill, deployed, or on active duty. Alternatively, the member's location doesn't need to be open to the public if the member has not participated remotely in a 13D.02 meeting from an inaccessible place more than 3 times in a calendar year and has been told by a healthcare professional that they should not be in a public place because of medical or family reasons. Public bodies must provide notice of their regular meeting locations, as well as the locations where members will be participating remotely. However, the locations of members who are participating remotely due to military service or for the listed medical reasons don't need to be noticed or open to the public. Finally, the meeting minutes must include the names of individuals who attended via interactive technology, as well as the reason the member was attending remotely. Many public bodies may still be familiar with the requirements of holding meetings under Minnesota statutes section 13D.021, and we'll walk through them as a brief refresher. So, under 13D.021, any public body can hold a meeting by telephone or interactive technology so long as the following conditions are met. First, the presiding officer, chief legal counsel, or chief administrative officer for the body must determine that an in-person meeting of members of the public body is not practical or prudent because of a health pandemic or Chapter 12 emergency. Again, this is the threshold requirement for whether your body should hold meetings under this section. In other words, you need to determine whether it is safe for the public body's members to meet in person at a regular meeting location. If a quorum of the body can meet in person, then you should not meet under section 13D.021. Second, members of the body must be able to hear each other as well as all discussion or testimony. Next, members of the public who are attending at the regular meeting location must be able to hear all discussion. Also, at least one member, the chief legal counsel or the chief administrative officer of the public body, must be physically present at the regular meeting location. However, both requirements are contingent on whether attendance at the regular meeting location is feasible due to the health pandemic or emergency declaration. Finally, all votes must be taken by roll call. Other considerations that you should keep in mind when it comes to holding meetings under Section 13D.021 are that public bodies must, to the extent practical, permit the public to monitor meetings electronically from a remote location. Public bodies must still adhere to the applicable notice requirements of Section 13D.04, and the notices must include the fact that some members of the public body may be attending remotely, as well as include information about how the public can also attend the meeting remotely. Finally, if your body or entity permitted the public to provide comments at in-person meetings prior to the pandemic, you are obligated to find practical ways that would permit the public to provide comments during remote meetings held under Section 13D.021. One last note I want to highlight is Advisory Opinion 21-003. In the opinion, the commissioner discussed a situation in which a school board was using 13D.021 to allow a quorum of members to meet in person, but did not permit members of the public to attend in person. The commissioner found this to be a violation of the open meeting law. Essentially, when more than a quorum of members are attending a meeting in person, then you haven't met the first requirement that an in-person meeting is not feasible. As an added note, there is no mechanism in the open meeting law that permits in-person meetings of public body members while limiting the public to remote monitoring. One last issue I want to highlight before turning to our potpourri of questions is the open meeting law and its interaction with data practices. Section 13D.05, subdivision 1, states that meetings cannot be closed on the sole basis that the public body is discussing not public data. In fact, the law permits public bodies to discuss not public data during an open meeting without liability, so long as the disclosure is related to issues that are within the scope of the public body's authority and is reasonably necessary to conduct its business. Any not public data that are disclosed during an open meeting retain their original classification, but the record of the meeting is public. Advisory Opinion 21-002 discusses this aspect in more detail. One other issue to highlight is Section 13.601, which governs data about applicants for appointment to a public body, as well as correspondence between elected officials and individuals. So that may be a worthwhile section to review. Additionally, government entities will want to consider whether elected public body members are considered employees for data practices purposes. If the members are considered employees, then the data classifications contained in Section 13.43 would apply. If not employees, then data about the elected members would be presumptively public. We suggest that a public body make a clear determination on the record, or the entity have a specific policy in place when it has decided that public body members are employees of an entity for data practices purposes. So that was a quick overview of the general requirements of the open meeting law. There are other provisions, such as sections on social media, as well as on enforcement, that I also recommend you take time to review on your own. However, I did want to save some time to discuss various questions we have been seeing related to the law. So let's turn to the potpourri portion of the webinar now, where we'll answer some of the interesting questions we've seen come up in the past few months. The first question we have is a situation in which a member of the public contacted our office to explain that residents of a city had observed city council members going out to eat with city staff at various restaurants after the council wrapped its regular meetings. The question this member of the public had for us was whether the city council was violating the open meeting law. Whether an open meeting law violation occurred in this situation depends on the specific facts of what happened. Let's walk through what to keep in mind. As mentioned earlier, the open meeting law does not define a meeting that is subject to the law's requirements. Rather, we must rely on the Minnesota Supreme Court's decision in Moberg, which explained the open meeting law applies to a gathering of a quorum or more members of the governing body at which members discuss, decide, or receive information as a group on issues relating to the official business of that governing body. Additionally, the court explained that chance or social gatherings are not subject to the open meeting law. In other words, it's not an automatic violation of the open meeting law if the council members gathered in a social setting with city staff. Rather, the important aspect regarding this gathering is whether there was a quorum of city council members who were discussing, deciding, or receiving information related to their official business. So, there probably would not be an open meeting law violation if the city council members had dinner with city staff where the only topics of discussion were the Minnesota Vikings' recent football season and whether the high school basketball team was going to make it to state. None of these topics are probably related to the council's official business. However, there probably would be a violation if the dinner conversation included discussions about the city budget, current staffing levels, and the best ways to offer tax incentives to draw in new business to the community. Again, the specific facts and context of the situation matter. And as a reminder, public bodies should remember to keep in mind the perception that might be given to the public if all members of a public body are getting together with staff informally immediately following a meeting. Although these dinners may not violate the open meeting law, the public could quickly become suspicious that a public body is conducting additional business outside of an official meeting. As I mentioned before, losing trust of the public and attempting to mitigate complaints can often be more challenging than defending against a formal complaint alleging an open meeting law violation. Our second question involves closed meetings. Specifically, a school board informed the public during a regular meeting that it was going into a closed session. However, the board members never held a specific vote to go into a closed session. The question was whether the school board violated the open meeting law. The open meeting law does not contain any requirement that creates an obligation for public body members to hold a vote in order to close a meeting. If a public body wants to include such a vote as part of its process when closing its meetings, it's certainly welcome to do so. It's just simply not required by the law. However, as mentioned earlier, the open meeting law does require a public body to take other specific steps before closing a meeting. These steps include: first, a public body must make a clear statement on the record that it is closing its meeting. Second, the public body must give the specific statutory section that requires or permits the meeting to be closed, or identify in some way the statutory authority allowing the closure of the meeting. Last, the public body must specifically describe what will be discussed during the closed meeting, which requires more than simply identifying possible discussion issues. For example, an appropriate statement in this situation could be the school board chair announcing the meeting will now be closed as permitted under section 13D.05, subdivision 3A, in order to evaluate the performance of the superintendent. The school board would be making a clear statement on the record with a public announcement that describes the statutory authority and description of what will be discussed. Another question that we received was related to public body members selecting a new chair. The question for our office was whether the law permitted the board members to vote for a new chair by using secret ballots. The short answer here is probably not. The open meeting law doesn't directly mention secret votes. However, Section 13D.01, Subdivision 4A, does require public bodies to document all votes in a journal of votes or in a collection of meeting minutes, which cannot be done if votes are cast in secret. Additionally, past case law has also clarified that a public body cannot hold secret votes. Specifically, the Minnesota Court of Appeals held in Mankato Free Press versus City of North Mankato that a city council violated the open meeting law when it held a secret straw vote to narrow down a list of finalists for a city administrator position. Specifically, the court wrote, "A city council meeting is not really open to the public if the council is conducting its voting in secret. Secret voting denies the public an opportunity to observe the decision-making process, to know the council members' stance on an issue, and to be fully informed about the council's actions." That said, I imagine some of the concern here was that there may be undue influence on the chair election when conducting a roll call vote. So I think there could be a reasonable process where the board had members write down their choices for chair, and those votes are given to a staff member who would then read the votes aloud along with the name of the board member who submitted that vote during the meeting. This would allow all board members to submit votes without influencing each other by going in order, and it would also allow the public to understand how each board member voted. In fact, the Commissioner of Administration noted in Advisory Opinion 10-011 that a straw poll complied with the open meeting law when the results were revealed during the meeting. Overall, though, the board members cannot vote anonymously when it comes to deciding who should serve as chair or when deciding any other matter. Another question we saw is related to a board going through a process to update its various policies, and the board members wanted to set up a shared Google document where the various members could add comments to identify specific changes and suggestions they would like to be made to the policies. Other members of the public body can also see these comments and respond. In short, it would be a collaboration document that makes it a bit easier for board members to carry out the work. Can they do that? This process is probably not permissible under the requirements of the open meeting law. Here, you have a quorum of the board members who would be essentially discussing information related to the board's official business. I'll note that I have discussing in quotes here because the Moberg case that defined what types of gatherings were considered meetings for the purposes of the law was decided by the Supreme Court in 1983, and I have some doubt that the court was contemplating Google collaborations back then. However, the Commissioner of Administration has issued advisory opinions stating email communications related to official business that are sent among a quorum of public body members can be an open meeting law violation. So collaboration on a Google document is not too far afield from sending emails back and forth among public body members. That said, it is helpful to conduct this type of collaborative work at times, and there could be some alternative processes to consider. For example, the public body could designate an ad hoc committee of less than a quorum to work on suggesting policy changes. Of course, you'll need to be cautious that the group is not set up in a way that is intended to do the work outside of the view of the public, which could be serial meetings and result in a violation of the open meeting law. So don't be rotating committee members on and off, and make sure the ad hoc committee will only be drafting proposals that will then be reviewed and decided upon by the full board during an open meeting. Additionally, your body could hold special meetings that are open to the public, but the meetings operate more as informal work sessions. There's no language in the open meeting law that states a public body must follow Robert's rules or other meeting procedures. So your public body could have these more informal sessions where there's just a focus on the work without the limiting structures of formal procedural rules, which could still allow the public to observe the board's work. Alternatively, the public body members could work independent of each other and then send all suggestions to the professional staff, who can then review the suggestions and provide an overview of possible changes during a regular meeting where the board members can further discuss and decide on any changes. For our next question, a 7-member board has several committees that are subject to the open meeting law, and the legislative committee has 3 members from the board, which is less than a quorum of the full board. However, the board chair, who is not a member of the legislative committee, is planning on attending and participating in the committee's upcoming meeting. The question is whether this board needs to provide any additional notice for the committee meeting. In this type of situation, additional notice will be required. The board chair participating in the committee meeting means that there will be a quorum of the full board at the committee meeting. As a result, both the committee and the full board would be holding meetings because a quorum of both groups would be gathering to discuss, decide, or receive information as a group on issues related to the board's official business. And therefore, two notices would need to be provided. Let's walk through the notice processes. First, the Legislative Committee would be holding a regular meeting, which would need to be noticed via the schedule of regular meetings that the public body keeps on file at its primary offices. Second, the full board would be holding a special meeting, and the board would need to provide the applicable special meeting notice. The special meeting notice must be posted on the public body's principal bulletin board or usual meeting room door that includes the date, time, place, and purpose of the special meeting, which would likely be the information related to the committee meeting. Remember, special meeting notices must be posted 3 days in advance of the special meeting. From a practical perspective, public bodies may want to put some procedures in place for when public body members want to attend and participate in a meeting of a committee that they do not serve on. This will help ensure that the public body does not accidentally run afoul of the open meeting law in situations where a quorum of the full body may happen to show up to a committee meeting. As a side note, Advisory Opinion 19-012 addresses this very issue, and it's a good resource if you want to take a deeper dive into this analysis. Here's our final potpourri question of the morning. Is there a statute of limitations for individuals who may want to file a complaint alleging a violation of the open meeting law? The statute of limitations to file an open meeting law complaint in district court is 2 years after the alleged violation. Specifically, the language of the open meeting law does not state what the statute of limitations is for filing a complaint related to alleged open meeting law violations. However, the Minnesota Court of Appeals issued an unpublished opinion in 2012 noting that Minnesota statutes section 541.07 paragraph 2 applies to open meeting law claims, which sets a 2-year statute of limitations. As an additional note, the Commissioner of Administration also takes the informal position of adhering to a 2-year statute of limitations when it comes to issuing advisory opinions on open meeting law issues. All right, I'm going to shift gears to a completely different topic before wrapping this webinar because some new cybersecurity requirements for nearly all government entities went into place on December 1st, 2024. I just wanted to quickly walk through what you need to know. So, Section 16E.36 requires all public agencies to notify Minnesota IT Services, which is the state's IT services agency, of cybersecurity incidents that impact computer services, systems, or people. This reporting requirement applies to all public agencies, which the law defines as any state agency, political subdivision, school districts, charter schools, intermediate districts, cooperative units under Section 123A.24, Subdivision 2, and public post-secondary institutions. The law also defines a cybersecurity incident as an action taken through the use of an information system or network that results in an actual or potentially adverse effect on an information system, network, or the information residing therein. I recognize some of this information may seem complex, but I have included a link to Minut's website on this slide that walks through the various entities that are obligated to report cybersecurity incidents, the types of cybersecurity incidents that need to be reported to Minut, as well as information about when and how to report. So I certainly encourage everyone to review that webpage for more information. That is our time for today. Thanks for your attention, and please feel free to send us any questions you have about the open meeting law.